Good morning, good evening, good afternoon. Going live. All right. So, when we last left off, we had just finished discussing the bill of particulars, and I had some input from various interested parties yesterday, and the various interested parties all seem to believe that these are the complaint. So, this document here that's signed off by the Detective Tully asking for an arrest warrant, stating there's probable cause. There's one for each case. So this is 2355 CR 001150. I'm told that this is the complaint. So every other state that I'm aware of does not turn an application for a complaint, an application for a criminal complaint, into a criminal complaint. It's a different document entirely. It's a document that's prepared, generally speaking, by the district attorney who's going to be prosecuting the case. It's going to set forth the elements of the charges, and it's not going to be anything like this. Now, I am somewhat unconvinced that those are actually the complaints, and I'm gonna tell you why that I don't think those are the complaints, and it's because of the rules of criminal procedure. Well, I started off by going to various attorneys' websites, and they did not all agree on everything. But it appears that the way that the criminal process works on felony cases is that felony cases are started in the district court, and in order to start it in the district court, you get a complaint. You take your application for a criminal complaint to the magistrate. The magistrate will then essentially do a probable cause hearing, where the defendant can actually participate in the probable cause hearing. Weirdly, at least that's my understanding of it from the about 2 hours worth of just digging around that I did. And then if the magistrate believes there's probable cause, then the magistrate will issue a complaint and either a summons or an arrest warrant. Well, a complaint and summons, unless you're already arrested, I should say. Anyway, and then if it is a case that you're entitled to an indictment, if it's a felony and you're entitled to an indictment, then you could demand an indictment unless you waive it. And if you don't demand it, and if the prosecution wants to keep it in the district court, then essentially they could limit the amount of time that you could get sentenced to 2.5 years in a Massachusetts equivalent of a county jail, and it'll get tried in the district court on the complaint. The various websites that I went through uh, basically said that as soon as a complaint is filed, a probable cause hearing is set, which would be required if there is no indictment. And generally speaking, those get kicked down the road until either the district attorney decides that he's going to proceed with the case in district court or until the district attorney gets an indictment from a grand jury. But either way, there is a complaint at the start of this. There is a complaint that gets this ball rolling. Generally speaking, maybe, I don't know, maybe they could start this off with a grand jury, get the indictment, and then proceed to get the arrest warrant and everything like that. So all criminal proceedings are commenced in the district court by a complaint. If you get an indictment, it goes up. If you get an indictment, it can go up to the Superior Court. You waive it. You have a probable cause hearing. Any person can obtain a complaint. The judicial officer has to authorize the complaint if there's probable cause. Now, the reason why I'm not sure that those are actually complaints is that an indictment and a complaint. So a complaint shall contain a caption as provided by law. Shall contain a caption as provided by law. This is the law. So a complaint to a district court starts off with Commonwealth of Massachusetts, for example, Suffolk, which is, I believe, where this particular one is filed. No, this is Stoughton. Okay. To the court of Holden for the transaction of criminal business within the county of blank. So this time it'd be Stoughton. AB in behalf of the Commonwealth of Massachusetts on the day of the year blank on oath complains that, and then there's the complaint, right? So it looks like it shall is mandatory, and the problem is that these don't have that. These also don't have any indication that they were confirmed, signed off by the magistrate. So I don't know. I mean, received is different. Received is totally different than actually being approved by the magistrate. So I don't know. I don't know what's going on or why. I am told that these are the complaints, but I have reason to doubt. So I don't know. But they're all pretty formulaic. They all lead off with the background, identifying the witnesses, etc. And then you have various things with that are pretty specific about what he did and when. Like on September 13th, 2023, Turtle Boy posted a blog entitled Can't Cover Up Part 142. Free Karen Reed billboard goes up on Route 1 outside Gillette Stadium in Foxborough. 2 more to follow on his website. Topic of the blog post was about a billboard that read Free Karen Reed with a picture of Karen Reed. Pretty praised the organizers of the billboard, etc. So it's pretty. These are pretty detailed. Like again, date, when it was, who did it, what did he do, etc. So if these are the complaint, then I don't understand why he needs a bill of particulars. Because they seem to be pretty specific. They seem to be laid out in plenty of detail. So I don't know exactly why they need a bill of particulars. So you got me. Another thing that kind of makes me wonder is the district attorney was talking about indictments for conspiracy. Now, I thought, being dumb and not see, I I guess my real problem with all this is I don't really care about this case. I mean, I don't have any knowledge of the background. I just don't really fucking care about it. What's your address again, Murbies? I'll send you some more guinea fowl. Send it to number 1 Happy Street, I guess. But there already is a conspiracy complaint. So if the conspiracy is in the indictment stage, and I half listened, I was working on other things while I was listening to the hearing that Turtle Boy was in on the emergency motion. If this is in front of a grand jury right now, that means all of these are in front of a grand jury. My guess is that all of these are in front of a grand jury, which means that the state is not looking for the 2.5-year maximum sentence for each one that he could be sentenced to, but they're looking for the 20-year jobs. They're looking to slam it home, and that's bad, and that's really fuck. I mean, for Turtle Boy, that's really bad. If you don't like Turtle Boy, it's probably pretty good, but if you like Turtle Boy, that's pretty bad. That's pretty bad. Went on a different one of these kind of caught me, and it really just made him look stupid, and I just wanted to go over it. He appeared on somebody else's. He appeared on somebody else's show. This right here. And it really bothers me that someone who is a reporter has so little understanding of how the criminal process works. He says, "I want the world." Turtle Boy said, "I want the world to know what happened here. They want the story to be silent. Nobody knows about it. They want to be able to find a jury pool that has never heard any of this shit before, so they can manipulate them the same way they have manipulated everybody else. And I'm not allowing them to do that. Happy to do it." So like Turtle Boy is literally talking about trying to taint the jury pool. Now it's not necessarily a crime. I mean, he's a reporter. I mean, he's supposed to report on these things, but his motivation is just so stupid. Like the whole point of getting a jury is that trying to get people that don't know anything about the case, so they form their opinion based on the evidence presented at trial by the prosecution and by the defense. So his statement, like they want to find a jury pool that has never heard any of this shit before, so they can manipulate them the same way they manipulate everybody else. Number one, it shows that he has no fucking idea that, guess what, the defense is going to get to present their evidence too. Rikita knows law. What are you talking about? The non-practicing attorney? I don't know what the fuck's going on, but I guess you guys are having fun in chat, so enjoy yourself in there. It's just problematic. And there was another thing that someone posted in my Discord that just really kind of, I don't know, I'm going to say concerns me somewhat.
I would still like witness intimidation.
Whoop.
Like read the statute, morons. The statute specifically says that you have to do it for the purposes of attempting to either alter alter their testimony or prevent them from testifying, period. I don't give a shit.
I don't know if you guys heard that, but he said that witness intimidation requires it to. Well, did you guys actually hear it? That'd be the big question. Is did you hear it? I have thumbs up. I don't know. Does thumbs up mean you heard it? Ooh, I could see on the desktop audio if you heard it. Let's try that again.
Still, like with
No.
intimidation, like
it's not playing the desktop audio. So I need to do properties. We're going to do, I guess, that. Okay.
I would still like witness intimidation. Like read the statute, morons. The statute specifically says that you have to do it for the purposes of attempting to either alter their testimony or prevent them from testifying, period. I don't give a shit.
And what he's missing there is the reckless disregard. The reckless disregard as to whether or not it's going to affect it. So it's just like, you know, my eternal disappointment with Turtle Boy. He is educated. He is a high school or a college graduate at least. He was a teacher, for fuck's sake, and he can't read a statute. He missed the or with reckless disregard for the fact that it may. I mean, like holy shit. First of all, it appears that he was actually intending to get them to change their testimony. But his misunderstanding as to what the law actually says is just like unfucking believable. Like I really am disappointed in him. I really am disappointed with him. Like, but going to someone's house and saying, "Hey, everybody, let's get her to change her testimony," is pretty much shows the intent to. So I don't know. Anyway, so that's Turtle Boy. That's Turtle Boy. Very very disappointed. Very disappointed in Turtle Boy. I guess I shouldn't expect too much. So anyway, I don't know if those were the complaints, but if they were, I don't understand the need for the bill of particulars. I mean, they seem to be very very detailed. If those are the complaints, if they're not the complaints, then the complaints should be amended to include all that information. At which time, I would suggest to you, or the bill of particulars should be given that just states those information. So. You're a Turtle Boy is a huge Fats Waller fan? I'm a huge Fats Waller fan, so I guess we have that in common. All right, so let's do a little bit of Chille. Chille to Castro. Chille to Castro. All right, we're going to start off with this bad boy. Let's see what we got here. 34 fucking pages. How is your amended complaint 34 pages, bro? Jesus fucking 40. Fuck. If if the order granting defendant's motion to dismiss, order granting in part defendant's motion to dismiss is 16 pages, where it analyzes the claims made in the complaint, one would expect the amended complaint would be 16 pages or less, right? 34 fucking pages. Well, let's get on. Let's get down to the causes of action. Holy shit. All right. Count 5, count 4, count 3, count 2, count 1. Arrest without probable cause or warrant under Nevada Constitution, U.S. Constitution, federal statute, state statute, common law. Fuck this guy. Absolutely fuck this guy. Oh my god. He changes the story about his arrest and adds another officer to the lawsuit. And he didn't listen to the judge who said keep it short. The judge literally says there was probable cause to arrest Castro for obstruction. So no matter what else, it's done. That claim was dismissed with prejudice. That claim was dismissed with prejudice. That's gone. That's done. So this is a 12b6. This is also going to be done because he had probable cause. Unreasonable seizure. The search is going to be the same thing, though. Did he not plead search? He does not grant search or seizure. But it doesn't matter. If the seizure, if there's probable cause for the arrest, then the search subsequent to arrest is also based on probable cause. This is a 12b6. Excessive force. Okay. That one survived, right? That one wasn't a 12b6. So that one's going to survive just like the other one did because it's based on the same stuff, I'm going to assume. Defamation? Fucking def the absolute fuck? Oh, Jesus H. Christ. Defamation? What in the fuck is... What did they say that was defamatory? Why is he talking about Arizona revised statutes? The fuck? What did they say that was defamatory? Sorry, we're looking for whatever it was. It was defamation. Individual defendants submitted police reports that contradict the video evidence, including fabricated testimony. All right, so I guess he doesn't lay down false police reports. False police reports with third parties. Holy shit. Oh. First of all, there is no defamation under the U.S. Constitution. There is no federal defamation statute. So it would be state statute or common law. I haven't read the Nevada Constitution, but I'm going to go out on a limb and suggest to you that defamation is not addressed in the Nevada Constitution. So, generally speaking, defamation requires damages. So not only does the defamatory statement have to be published, i.e., spread, but there has to be some damage associated with it, and there's a reason why it's very hard, generally speaking, to find an attorney to take a defamation lawsuit, especially on contingency. But that reason is generally speaking because damages are really hard to prove. Uh, there are a limited number of things that you can, generally speaking, under the common law, that that you can allege where you would not have to prove special damages, and you could skip straight to general damages. Those things are like talking about a woman being unchaste, accusing someone of having a venereal disease, accusing someone uh, of a felony that generally speaking would be ruinous to someone's reputation. So is shitting the spread in the marital bed defamation? Like, look, Jeff, I'm not going to kink shame you if that's what you like to do. You go ahead, brother. I mean, you just make sure that your woman's down with it, or else that could get a little uncomfortable for everybody involved. Um, but anyway, without those defamation per se kinds of categories, uh, Chille's going to have to prove that he lost money somehow because of these false police reports. He's going to have to prove he's not entitled to any general damages until he proves specials. He has to prove it. And like, I don't know if he realizes it. I went over this. I went over this when he sued Abrams and Peters. Peter. When he sued them for defamation, I said that means that they're going to be entitled to discovery on his financial issue because he's going to have to show damages. He's going to have to show dollar damages. When I say damages, I don't mean feelings. I mean dollar damages. Jeff was talking about the Heard Depp case. I think that wasn't a defamation kind of thing. I think I don't remember. I don't know what that was, but I would assume that would be something along the lines of like intentional infliction of emotional distress. Taking a shit in someone's bed, intentionally taking a shit in someone's bed, is outrageous to the point where you may be entitled to damages. It may, but again, you'd have to show those specials. You'd have to show that it hurt you. That's what you'd be entitled to. What you could show, and there has to be some dollar amount there before you're entitled to general damages. So he's dead in the water here. He's gonna, and again, truth is an absolute defense to defamation. So if those police reports are true, I mean, he has to. He's got enough. I don't think he has something there, and there may be something. I'm not familiar with Nevada law on defamation. I'm kind of just talking out of my ass with common law, with bar exam level understanding of general principles of defamation. But just like throwing out Nevada Constitution, U.S. Constitution, federal statute, state statute, and common law, I don't know that this is going to put them on notice very much, but okay. Well, him being cited and the criminal prosecution are tied together. The citation was the start of the criminal prosecution. And how much did that cost him? And the criminal prosecution, there's probable cause. And again, it's dollar damages. All this bullshit is just bullshit. Fucking defamation, dude. Oh my god. Doesn't Castro open himself up to massive? I don't know what massive financial discovery is. They basically what they can do is they can demand to know. Well, he needs to disclose the dollar amount. If he doesn't, they're going to do discovery to show exactly, provide all documents or receipts that show any dollar damages, any monetary damages, something along those lines. I'm sure they'll clean up the language. I hope they'd clean up the language from what I just said. But yeah, I mean, he opens himself up to some financial discovery at the very least. So, First Amendment, didn't he already plead First Amendment? And didn't they get rid of the First Amendment issue because he already had First Amendment retaliation. So this one he had leave to amend. All right. So his amended is what? It chilled his rights by following him. That's not. I don't understand. Tracking his movements. How'd they track his movements? Defaming him isn't shilling his rights. So, arrest and prosecution. First of all, the it's the district attorney that is prosecuting him, not the city of Las Vegas or the Las Vegas Metropolitan Police Department or the uh, officers involved. So they're not prosecuting him. Has he added? Has he added his anybody else? No. Sitco. What the fuck is a Sitco? Did he add? Did he add someone? Who the fuck is Sitco? Officer Sitco. Okay. All right. Okay. So that's not a new one. Hold on a second. This is a new allegation, or is this a prior allegation? Did he added this guy, didn't he? Hold on a second. He did. He added a new defendant without seeking leave of the court. He also appears to have added a new incident. So he added a new like I don't understand. You can't you can't just you can't just add a new incident to it and a new defendant. Oh, because you need a whole new summons. You need a new summons. He needs a new summons. I don't understand this at all. You're not supposed to just fucking add new defendants. Chilling of the First Amendment. Exactly what is chilling? I don't even know what chilling of the First Amendment is. The They didn't violate his First Amendment right. He's going to allege that blocking the camera, I guess, is going to be a violation of his right to speak. I'm going to guess, but I don't know what this is. I don't know what this is. So I would move to strike it because I that doesn't that would fail Twickball. I think it would fail Twickball. I have no idea what the fuck he's he's saying there. Oh, here's the First Amendment retaliation. How is that different from whatever, dude? Whatever. First Amendment retaliation under the Nevada Constitution. What is the Nevada Constitution's First Amendment? What is the Nevada Constitution's First Amendment? There's the amendments. What is... I fucking hate Chille. I fucking hate Chille. I don't really hate him, but Jesus Christ, bro. Jesus Christ. First Amendment retaliation has to be under the U.S. Constitution, Article 1, or First Amendment, and the 14th Amendment. First Amendment and the 14th Amendment of the U.S. Constitution, 42 U.S.C. 1983. That, it's not common law. It's not Nevada Constitution. It's not state statute. It's First Amendment through the 14th Amendment via 42 U.S.C. 1983. They already found probable cause. He's gonna lose on 6. He's gonna lose on 6. If I remember correctly, the court uh, granted leave. Yeah, there you go. So I have a feeling he's going to lose on 7. Now that the what's his name, Marquis Craig Anderson, Marquis Arbaugh. Now the court's told him basically what the court's looking for. Maybe Marquis Arbaugh will pull through, and Craig Anderson will pull his head out of his ass long enough to actually address supervisor liability. Maybe. Selective enforcement. Didn't he lose this one without leave? Didn't he lose selective enforcement without leave? So he has to recast as one brought under 1983 for a violation of 1981. That's what he has to do. Did he do it? 1983. But he just lobs out every single potential thing. Like this is just like I don't fucking know what I'm doing. I'm dumb. I'm ignorant. I don't know what I'm doing. So I'm going to throw out all the things and hope that the court is going to do the work for me and put it together because I'm just a pro se litigant. And on the one hand, he's always talking about how he's a 20-year constitutional law scholar and how he's, smarter than all these judges. And on the other hand, he wants the judges to do his work for him because he's a pro se litigant. It's like, bro. Battery, not assault? Just battery, huh? I think the court granted him leave to amend that, or otherwise not. No. There was probable cause, right? Wasn't there probable cause so that the so he did not plead battery previously. Well, he's going to lose on battery because they had probable cause. Oh, so they never addressed the battery claim. Okay, they never addressed it. That wasn't one of the ones they were trying to get rid of. Okay, I guess that's the punch in the nuts. So yeah, the punch in the nuts. If true, he can recover for it. Just him trying to ask for recovery under like 5 different statutes doesn't mean he's going to get like 5 different recoveries. But if he gets a recovery, then it could be under one or all of them, but it'd just be one recovery. Invasion of privacy. All right, let's see if the invasion of privacy. Dismissed with prejudice, so that one's gone. So he literally wasted his time uh, typing it in again because it's going to be 12b6. Negligence. Negligence based off the arrest and search. There is no negligence under the U.S. Constitution or under federal statute. Uh, the illegal detention, arrest, seizure, those are all have already been dismissed with prejudice, so he can't seek those. The retaliation, I think he could do without prejudice. Yeah, so he can allege it, I guess, for that. Use of force. Well, so use of force would be intentional. It's like so negligence doesn't. How do I phrase this? There are intentional torts and there are negligence based torts, right? If I so battery is an intentional tort. I mean to hit you and I hit you. That's battery, right? That's an intentional tort. Negligence is where I didn't mean to hit you. I did something negligently that ended up hurting you. So so they had a duty to carefully investigate criminal activity. I don't know. Well, that's already blocked. He's like he's taking something and he's trying to apply it in a situation where it just doesn't fit, and it's really hard to like articulate why it doesn't fit because you never see it applied in this situation. They had a duty to use care to avoid subjecting plaintiff to retaliation. Like retaliation is intentional. So he's trying to frame intentional acts as negligence, and it doesn't work. It doesn't work. Like you have a duty to use care to avoid subjecting me to being punched in the face by you. Well, you intentionally punched me in the face. It's not negligence. So I should look to see what he might have a claim for here. Reasonable care, well, negligence. The negligent use of force, maybe. Well, no, because the use of force would be intentional. use reasonable care to avoid and engage in. I don't know. I think his negligence claim is going to be dismissed, probably without prejudice again, but maybe with prejudice because he's had 2 bites of the apple. Failure to intervene under everything. See, 42 USC 1983 is not a negligence, it's an intentional. It requires intent. 42 USC 1983 requires intent. And again, for negligence, he's also pleading 42 USC 1983. 42 USC 1983 requires intent. Subjects or causes to be subjected. It requires intent. It's not negligence. You have to intend to do what you're doing. So it doesn't work for negligence. And failing to intervene isn't subjecting or causing to be subjecting. And I don't know where this where's Ninth Circuit? I'm looking for Ninth Circuit. All right. I guess that's what he's alleging right there. So that's your failure to intervene. It's case law. So I don't know why he didn't just cite it. Why he had to cite the Nevada Constitution. Like, Jesus fucking Christ. Count 13, civil conspiracy. Good fucking luck. Good luck. Just good luck. Abusive process. Nope. There was probable cause. Manel claim, failure to train. I think that one was dismissed without prejudice. So what about the Manel portion, not the supervisor liability, but the entity liability? Had leave to amend. All right. So this one he had leave to amend. He has to provide discovery will show further proof. Doesn't work that way. $5 million in punitive damages. Compensatory damages in an amount according to proof. Huh? Well, good luck on that. Costs of suit. All right. Well, good luck to him, I guess. Good fucking luck to him. What else we got? He got an extension of time. Then we have a response to motion 50. 50 was a motion to recuse. His garbage motion to recuse. His garbage motion to recuse. All right. Filed a motion for partial dismissal. Court entered its order granting, in part, the motion to dismiss. Now, based solely on the fact that Castro disagrees with the court's decision, Castro seeks recusal while attempting to relitigate the court's decision. Yada yada. Legal standard. Blah blah blah. We've been through this with Springer. We should know all about this. Although he's pro se, he's nonetheless bound by the same rules of procedure that govern other litigants. Yes, sir. He's failed to identify or even allege a single extrajudicial source. Yep. As established above, judicial ruling is not a basis for partiality. Yep. And perfect. Yep. Good job, Craig Anderson. It was concise. I like it. And it argued everything that we needed to argue. So perfect. Did it end? Did what end? Do you not see me? Do you not see me? I see you. Your channel. I still show him live. I still show him live, so I don't know. So that's it for Chille. Now for Springer. Oh, look at all this bullshit. Oh my god. Oh my god. I turned off rewind. I thought I turned back on. I didn't. It really? It's supposed to. It's supposed to have was that DVR mode? It's supposed to have DVR mode. I tried to make it have DVR mode. Speaking of which, I'm gonna take a little tinkle break. I'm gonna leave you with a little Fats Waller.
First you slide, then you glide for a while to the left, then to the right, get overside. Watch yourself, squeeze your gal. Here she comes. Look out for that funny feeling now. Yes. Tantalizing, hypnotizing, mesmerizing string. I can't get enough of it. Play it over again. I could dance forever to this refrain, to that 12th Street, talking about 12th Street drag. Bring it on out there, yeah. My mercy. Oh.
Well, I don't know. Am I live? Who knows? Who knows? All right. Well, I'm going to guess I'm live. I'm going to guess I'm live. Hi, Nima. I have this error on my side that says YouTube isn't receiving enough. You think I'm dead? I'm live. Yes, I'm live. All right. Okay. I don't know where we left off. Today's the 3rd, so about a week ago would have been like the 27th. Well, the big deal is that the court granted the order, or granted the motion, or granted leave to file the motion, I guess, because they had the right. As I said, they had the right to file it by right. And the court goes over how they had the right to file it. So he's just gonna let you file it. So they file it. Yay, they file it. Do I even want to look at this? So they filed the amended complaint. That makes the motion to dismiss go away because, well, there's an amended complaint. The response to motion. Man, I don't know if I want to go into all this. So again, they start off with Thomas Paine. They really like Thomas Paine. General allegations. I think we've been through the red line version of this. So I'm not going to go over it. What are you? What in the fuck, bro? What in the fuck? So on the 27th, the judge denied defendant's motion to dismiss. On the 27th, oh, can, wrist, hand, for Josh. This is for Josh. Is my wrist big enough? I probably should do a crotch grab too, but I'm not wearing any pants, so that would go bad. But this bothers me. On the 27th, the motion to dismiss was denied. And then on the 29th, they file their reply. Oh my fucking god. Oh my fucking god. What the fuck is this? So they label it a reply in support of the second motion for TRO. But then they say that it comes with it's his response to the motion to dismiss. So they filed 65 is their motion for their second motion for a temporary restraining order. Then the defendants filed a response or opposition to it. At 67. And then there was a notice. All right. Well, we'll fucking go through it, I guess. So I'm going to guess that this is not their response to the motion to dismiss, number 57, and that this is, in fact, a reply in support of their second motion for TRO. It's clear from the instant response, from defendant's response, from defendant's opposition. Did you get booted? I don't know. Did you get booted? My little studio thing still says my stream is excellent, so I don't know. You tell me. It is clear from the instant response that this case originates from a failure of the defendants to understand the law or the Constitution. The case originates from your fucking complaint. To be clear, plaintiff does not dispute that New Mexico Supreme Court has acted in its constitutional and legislatively delegated authority to lawfully promulgate rules for safety of citizens appearing in court, yada yada. Plaintiff acknowledges that under those lawful rules, and violations of those rules may lead to punishment under the district court's contempt powers. He's talking about contempt. Great. Talking about contempt. But what the response betrays is what defendants truly. Defendant's response is incorrect on certain factual statements or misconstrues certain facts, which plaintiff addresses and clarifies as follows. Plaintiff is never harassed in any typical use of that word, or threatened, again, in any typical use of that word, any 7th Judicial District Court employee, nor does defendant properly allege that plaintiff has done so because the video evidence documents that he has not. But didn't the court find that he did? Didn't the court find that he did? There was the notice of the appeal. Where was the motion for rehearing? Where was the motion for rehearing? There's the order denying it. Emergency motion for reconsideration, and then the order. Here's the amended order. Wait, it wasn't in this one. It was in the hold on. It was in the denial of the motion for recusal, right? That's where the is this one. Damn it! I don't remember where it was. We've gone over this before. God damn it! God damn it! Gone over it before. I don't remember exactly where it was. I don't remember exactly where it was. However, uh, it's somewhere in there. It does state that the court did find that he had harassed the gal. And based on that, I'm going to say that his this stuff right here, the harassed, is not going to go so well for him. The whole part about him calling the clerk an escort, if I remember correctly, that's what the court found was something that a reasonable person might feel harassed by or something like that. The Moriarty incident, of which the defense claimed harassment, was, in fact, further attempted petitioning for redress of a grievance by plaintiff. Importantly, no case stands for the proposition that outside of a courtroom that the court may require the petitioning activity or speech to be polite or non-profane. Again, he's citing California, or Cohen versus California, which is not quite on point. The Cohen versus California was a review of a statute that would have made the word fuck in and of itself a breach of the peace. I need minions. So Cohen versus California, what the Supreme Court was determining was, well, you can't just criminalize the word fuck because it can be used in a political speech. The specific political speech that the court was considering was the jacket said fuck the draft, right? That's political speech. Now, just because it has a naughty word in it doesn't allow the court to criminalize the speech, but it's not. I don't believe that anywhere in here the court was trying to criminalize any speech based on naughty language, and there was no statute that the court was interpreting as saying if you say this bad word. So it's just the inopposite. Everybody likes to say Cohen versus California stands for the proposition that you can swear like a sailor, but it doesn't. It doesn't say that because, say for example, you say F-U N-word to a black guy, that is most likely going to be fighting words. It's most likely going to be something that would tend to incite an immediate breach of the peace, right? So that could be something that a state could criminalize under a disorderly conduct statute because it is fighting words. It's outside of the protection of the First Amendment, right? So what the videos do show is that plaintiff encouraged other citizens, if they were displeased by the actions of their government, to exercise their First Amendment rights to speech critical to their government and petitioning their government for redress, which is exactly the purpose for which the founders adopted the First Amendment. I'm not sure entirely that call floods are exactly the purpose that our founders adopted the First Amendment for. I'm not entirely sure of that. I'm sure that what they were saying was I'm sure that what the founders were intending, because there weren't phones back then. What is this, a soft A and not a hard R, and you know the guy? Well, I mean, I'm sure that that there will be considerations for the circumstances surrounding it. I mean, maybe you're inviting him to an evening of fun and frivolity. I'm not here to judge. Again, your sexual proclivities are yours, and I'm not going to judge you for what you do behind the privacy of your own bedroom doors. That's one thing. Like petitioning your government for redress of grievance, like that would be like signing a petition. It's literally called a petition, so it's pretty obvious that it would fit into what the First Amendment is dealing with. The other thing is like a petition that you file with the court. So you can use a petition to access your legislative government. You can use a petition to access your executive branch government. And there are also petitions that you use to access the judicial branch of your government, right? Call flooding a clerk isn't going to get you a result. That's not petitioning your government for redress of grievances, right? That's something more akin to That's something more akin to like tying up the phone lines or whatever. And again, we're quoting James Madison instead of quoting like actual law. You would think one would think a lawyer would actually cite to a law. Again, contrary to the statement of defense, plaintiff did not say that he deleted evidence. He said it was his practice to delete emails whatsoever prior to receiving the letter. Again, as I've already gone over, that is not relevant. Once you are on notice that those things may be relevant to an upcoming case, regardless of the point of a letter, generally speaking, a plaintiff will send out a spoliation letter so that a defendant who is otherwise unaware of his obligation to preserve evidence is now placed on notice of his obligation. The plaintiff already knows that he's going to file the lawsuit, so the plaintiff is already under an obligation to preserve evidence that may be relevant to the upcoming litigation. So Springer's attorneys are entirely off point. The plaintiff was already under an obligation to preserve that evidence. Because imagine this situation. If things worked the way that Springer's attorney wanted them to work, then if you were going to be the plaintiff, what you would do is you would go and you would eliminate all of the potentially harmful evidence immediately, and then you would go and file your lawsuit without repercussion. If it worked the way that Springer's attorneys want it to work, you could abuse the system by proceeding down that path. So it doesn't work that way. You have an obligation to preserve the evidence when you are aware of the litigation, of the upcoming litigation. Now, California doesn't have spoliation letters. That's a federal thing. So you can't send out a spoliation letter prior to filing a lawsuit, or you can, I guess, but they're not under any obligation to actually preserve any of the evidence. So it's generally speaking not recommended that a plaintiff do that prior to filing the lawsuit. But once the defendant has been served with the lawsuit, then the defendant is under an obligation to not destroy evidence. So he's not deleted evidence after receiving the litigation hold letter, and to say it otherwise is false. They don't have to say that. It's literally, Springer said, I have deleted evidence in not so many words. It's my custom and practice to delete emails after I've read them. Well, great, right? Great. But you're the plaintiff. The litigation hold letter, look at the words, the litigation hold letter. You already were in litigation, or you knew you would be. Major dial is not an associate, whatever that term means, to defendants of plaintiff. Plaintiff has no authority or control over Mayor Dials. Dials something. Dials possessive. Mayor Dials something or the other. Something. Any more than he does any other adult person. Neither Mayor Dial nor any other concerned citizen who has accompanied plaintiff was in his employ or legally obligated to take direction from plaintiff. Well, I'm not entirely sure of how sound this reasoning is. If you go out onto a street corner and you say, follow me to the mayor's house and we'll lynch him, right? And you start marching out and the crowd follows you, are you responsible for them? Yeah. You have a responsibility for them. Are they in your employ? No. Are they legally obligated to take direction from you? No. But you are inciting that crowd to violence, to take violent action. So it's a non sequitur to say, well, they weren't legally obligated to take direction from you, but did they take direction from you? That's a better question. Were you trying to get them to do a thing and then they did it? Is a better question. Again, the statements by Mayor Dial and plaintiff to NMSP about the court staff being unworthy of respect or the judiciary staying in their lane are matters of opinion and criticism of their government's conduct, which citizens have a right to voice without fear of punishment from the government. Well, again, a courthouse is a non-public forum. At best, it would be a limited public forum, but it's probably a non-public forum, right? And even if it was a limited public forum, you'd still use the same analysis as a non-public forum. So it's a distinction that lacks a difference, right? Is the restriction reasonable? Is there a legitimate reason for the government to have that restriction? And is the restriction rationally related to achieving that legitimate government purpose? And courthouses are not places where you go to protest. You don't go into a courthouse to protest. So claiming again, see, notice the entire lack of citation to authority. I don't know what aversion Springer's attorneys have to actually citing authority. This is ridiculous. Defendant's statements about plaintiff bringing a gun to court is an outright falsity, is clearly demonstrated by the video itself. Also, Exhibit 1, defendant's blatant misstatement of material fact to the contrary borders on violative of the requirements of Rule 11. Borders on violative of the borders on a violation of Rule 11? Borders on a Rule 11 violation? Defendant's statements about bringing a gun to court. They say he brought a gun to court. Clearly demonstrated by the video itself. How would a video demonstrate that you didn't bring a gun to court? We went over this kind of thinking with what's that fuckwit's name? Texas Sheepdog, right? So Texas Sheepdog allegedly brought a fake gun, and he said, the video shows blah 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 that I didn't bring a gun, and it was a fake gun, and this and that. But how do you know? How does anyone know you don't have a gun? He's like, I took it and I put the fake gun in my car. How do they know that? How do they know that? Right? Am I carrying a gun right now? Am I armed right now? I could say, well, you look at the video. You can see I'm not armed. You don't see a gun in the video, right? Look at the video. There's no gun. But how do you know I'm not armed? How do you know that I don't have a Ruger under my nutsack right now? You don't. Videos can show you what someone has, but it can't prove what they don't have, right? So in the video, if you see him with a gun in his hand, you can say, well, he's obviously armed because you could see the gun in his hand, assuming that you could prove that it's a gun and not a fake or whatever. But it can't show you that he's not concealing a weapon somewhere else on his body. And I don't think any of this turns on whether or not plaintiff brought a gun to court. I can't imagine why it would turn on whether or not plaintiff brought a gun to court. If he did bring a gun to court, don't they have metal detectors? Every court in California has metal detectors. But maybe that's just California. Maybe New Mexico operates on a whole different wavelength. Why are we talking about employment law? Christ. You're wrong, Matto. I have a giant nutsack, so they probably can't see underneath it. The court has jurisdiction over requests for injunctive relief based on new facts occurring after the interlocutory appeal was taken. So this is a case that the defendant cited. So they finally cite authority. Now let's take a look. Let's see if they plead facts. Let's see if they plead facts that were already or that are part of the. Oh, Jesus fucking Christ. See, they're pleading the same facts. This is the only new thing that they've got. And remember, the new thing that they've got is the scam takedown that YouTube did and subsequently reinstated his video. Plaintiff's motion does ask the court to reconsider its prior decision, but it asks the court to do so on the basis of facts that were not placed at issue in the first motion or had not occurred by the time the court decided that motion and are proper for consideration now. Except you plead all the old facts. So just the new facts would only potentially get injunctive relief for the defendants. I mean, assuming that plaintiffs can actually prove that the defendants had some sort of coercive control over YouTube, assuming they could prove that, and assuming the defendants actually did instruct or force YouTube to take down the video for scam. And let's just assume that YouTube wasn't able to put it up, right? And let's assume that the plaintiffs can prove all of this. Then what the court would have what the court would be able to rule on would be whether or not to issue injunctive relief against the court and the court employees taking down YouTube videos. It would have not, but they're not asking for that. They're asking to take down or to force the defendants to allow plaintiff to go to court on non-court related business. And to do things at court that plaintiff wants to do, and the court doesn't want plaintiff to do. So he's entirely wrong. And the newly discovered evidence. So this should be a separate. Like he could file a separate motion for injunctive relief based on the facts, but he didn't do it. Plaintiff has met the requirement for injunction, and they've supplied no evidence calls into question the evidence supports the injunction is proper. He's not likely to succeed on the merits. I'm going to be wrapping this up in a minute anyway, so we'll just power through. Defendants cannot legitimately argue that they will be harmed by being required to follow the constitutions and the law That's pretty fucking presumptuous. He's still arguing about contempt. I guess there were the criminal contempts that the state filed or declined to file. Jason, that noise is guinea fowl. So based on that, I'm going to wrap this up. I don't see them getting their renewed motion for a temporary restraining order or injunctive relief. But I'm going to wrap it up. Thanks for watching. Have a great day.